Thank you, everyone, for being here again this morning. My name is Katie Principali. I am a member of Drexel's Law Review as the articles editor, and I'm here to introduce our keynote speaker, Michael Ashley Stein. Michael Ashley Stein is the co-founder and executive director of the Harvard Law Project on Disability. He has been a visiting professor at Harvard Law School since 2005, considered one of the world's leading experts on disability law and policy. Stein participated in drafting the UN Convention on the Rights of Persons with Disabilities and advises a number of UN bodies and national human rights institutions. He also works with disabled people's organizations and non-governmental organizations around the world and actively consults with governments on their disability laws and policies. His work has brought landmark disability rights litigations globally. Stein has received numerous awards in recognition of his transformative work, including the inaugural Morton E. Rudderman Prize for Inclusion, the inaugural Henry Viscardi Achievement Award, and the ABA Paul G. Hearn Award. His authoritative and path-breaking scholarship has been published worldwide by leading journals and academic presses, and has been supported by fellowships and awards from the American Council of Learned Societies, the National Endowment for the Humanities, and the National Institute of Disability Rehabilitation Research, amongst others. Stein holds an extraordinary professorship at the University of Pretoria Center for Human Rights, is a visiting professor at the Free University of Amsterdam, and teaches at the Harvard Kennedy School. He earned his Juris Doctorate from Harvard Law School, where he became the first known person with disability to be a member of the Harvard Law Review, and a doctorate from, a doctorate from Cambridge University. Stein previously was a professor and a Kabul professor at William and Mary Law School, taught at New York University School of Law and Stanford Law School, and was appointed by President Obama to the United States Holocaust Memorial Council. In addition to Professor Stein, Hezzy Smith, a research associate at the Harvard Law School Project on Disability, will be fielding questions. Hezzy Smith is a trilingual attorney, a proud sibling, and an HPOD research associate responsible for much of HPOD's self-advocacy and programming. He has worked closely with self-advocacy and disabled people's organizations, both in the United States and abroad, to advocate, research, and produce awareness-raising materials. His Spanish, English, and Bangla language materials have shaped disability rights, strategic litigation, and important decisions by national and regional courts. And his disability rights scholarship has appeared in collections published by Cambridge University Press, the Oxford University Press, as well as both US and international law reviews. Welcome, both of you, and we look forward to hearing your thoughts.
Thank you ever so much for having us, and thank you for the introductions, Katie. It's a pleasure to be here. I note many old friends who are here, both as panelists and in the audience. Dean Dan, I wish I could be with you in person. The same for my friend Alex Geisinger, and Emily, thank you for the invitation. Amy, thank you for your recent contributions to another book. One day soon, hopefully we'll all be in person. We've changed the title of our talk a little bit because we've been mulling it over and think we'd like to present a slightly more positive view of the IDA and those who are neurodiverse. So instead of thinking entirely about how people fall through the cracks, we're going to frame it moderately optimistically about how we're having growing pains with the IDA. It has expanded, it's done some good things, but it's having some pushback as well. So first, I think it's very appropriate to recall the relationship historically that persons with disabilities, especially those who are on the spectrum or who have intellectual or developmental disabilities, have had with the American education school system. Schools, maybe we should say schools, have had a torrid history of human rights abuses, ones that we now relate in the international sphere as torture. So the US's first school or institution for children with intellectual and other disabilities was the Fernald School. It's ironic because it's about a 20-minute drive from where I'm sitting here in Cambridge, and I'm sitting on Fernald Drive. But you know, in the 1940s and 50s, the Fernald School gave 74 or more kids between the ages of 7 and 17 cereal containing radioactive iron and calcium. This diet was part of an experiment to prove that the nutrients in Quaker oatmeal, which I happen to love, but maybe I shouldn't, travel through the body. Students who were invited to participate weren't told they were consuming radioactive oatmeal, and for all they knew, they were part of a science club. Eventually, Quaker and MIT, which collaborated on the study, agreed in 1998 to pay a class action lawsuit of $1.85 million, or roughly less than $25,000 per student. Alex Green, who's a legal historian and a fellow at one of the HLS programs, has been working for the last several years to identify 300 unmarked graves in the Medfern Cemetery where Fernald School residents were buried. Thankfully, we know the names of about 298 of these residents, and Alex was working with the local high school to develop profiles for each. So we've come a long way. That's a pretty gruesome history. When the Education for All Handicapped Children's Act came out in 1975, pushed by Indiana Representative John Bradamus, who wound up being my president when I went to NYU as an undergraduate, fewer than half of the 8 million American kids with disabilities were receiving an appropriate education. 1.75 million of them were outright excluded from public schools, and another 2.5 million of them were sitting idly in regular classrooms awaiting the time when they were old enough to drop out. That's not my characterization. That comes from a US House of Representatives report. Today, roughly the same number of kids, 7 million kids, with disabilities are receiving some form of special education services and support through the US public schools. So we see an improvement. In 1990, the same year that the ADA, Americans with Disabilities Act, which we are celebrating its 30th anniversary this year, was passed, the Education for All Handicapped Children's Act was revised and called the Individuals with Disabilities Education Act, IDEA, and that's what we're referred to. And that guarantees a free and appropriate public education by all children in our public schools, and they are to receive individualized education programs, IEPs. There are some real limitations to the IDEA. I don't want to overstate the case. Too often students have to fail in order to prevail in due process hearings or court. So parents and kids are put into this amazing catch-22, where in order to prove their disability, in order to prove their eligibility for services, in order to receive adequate services, they actually have to fail at school. This is not the right way we want to look at it. Similarly, the IDEA puts the burden upon parents and on occasion the kids themselves of having to prove that the services they're receiving are inadequate. And think about this, if you're not from an extraordinarily privileged socioeconomic background, maybe even with legal training, think about the parents who go into these hearings with a board of experts up against them, the superintendent and teachers with whom they have to interact with afterwards, saying the opposite or trying to push back against them, no legal help provided to them by means of basic course, and they have to prove that their kids are entitled to these services. So this is one of the limitations we have within our US civil rights style world, in that it's not a human rights statute. They're not entitled to a government agency or a protector or a lawyer to bring these cases, and they have to push the ball all on their own. Plus the Supreme Court, of course, in Buchanan, took away the fees and the other ways that enable these parents to push forward these cases. Nevertheless, the IDEA is a world leader. You know, students nowadays coming up through the US education system assume that kids with disabilities are supposed to be in school and in class with them. With very few exceptions, the IDEA is looked to from around the world as one of the leading practices. The exceptions, of course, are Finland, which has the best education system in the universe, and the UK, which has a very strong inclusive education system. But other countries, for example, you know, we work in 44 at the Harvard Project on Disability, and we encourage everyone to visit our website at hpod.org and sign up for newsletters. But, you know, most of the places that we work in the world, even OECD countries, privileged countries, look to the IDEA and look to the norm of having kids with disabilities in class as something almost aspirational or, or idealistic. One country that we work in a lot, Israel, which is an OECD advanced country, we're only now entering the second year of teeny tiny pilot projects of having kids with disabilities in inclusive settings. So the IDA really in many ways is remarkable. Nevertheless, it's still undergoing growing pains. And we like to think that, maybe this means the teeth are growing into the statute and we're seeing progress in it. But we're getting pushback as well. And there are three that we'd like to touch on in our remarks regarding students who are on the spectrum or who have intellectual or other disabilities and who are transitioning from secondary to post-secondary settings, meaning from high school to higher education, whether higher education means community colleges or universities or other settings. The first area is inclusive post-secondary education and higher education programs. Only recently have students been able to begin to access these historical sites of exclusion. And although this is welcome, the same old NIMBY attitudes, not in my backyard, continue to keep them out and continue to be evident in the kind of unequal treatment that they receive while accessing these programs. The second area that we'll touch upon is the transfer of rights process. The idea that under IDEA Part B, when students who are receiving special education services become the adults in the eyes of the law, but are still in school and are still eligible for these services, whether these children are transferred their IDEA rights or not, and what happens afterwards. And it has taken lots of states flat-footed, and they have very unequal and uneven practices. So it raises questions like, do we expect 18-year-olds to all of a sudden be able to wield their rights as adroitly or competently as their parents who have been forced to do this for the last, 14, 15 years? Or do we continue to treat them like children and apply guardianship statutes that take away their rights and put these decisions into other people's hands, their parents and sometimes others? Or do we do something in between? It's dramatically unclear. In any case, the states are inconsistent across the board on how to implement these rights and also about how we as a society perceive these students with autistic spectrum disorder, intellectual and developmental disabilities, and so on. The third area has to do with dual enrollment courses. The emergence of dual enrollment courses is the idea that we're trying to transition students to higher education. And so while they are technically still in high school, can they take college level courses in which they will earn credits and get some progress towards degrees? This area of transitions has really exposed and is testing presumptions that are baked into the IDEA. Increasingly, states are trying to diversify and trying to increase the pathways to post-secondary education opportunities, and dual enrollments has done a lot to get this traction. But the colleges themselves, the colleges of higher education themselves, which know that they are under Rehab Act Section 504 and ADA obligations, are often incredibly unfamiliar with the IDEA, and even at times will say they're not under IDEA obligations. And so we wind up having these universities and others, on the one hand, accepting students to get some traction and to get some movement into areas of higher education, but at the same time, failing to continue the idea of a FAPE, free and appropriate public education, and the accommodations that go along with it. So we're seeing some progress. We're also seeing some problems and some teething pains in this progress. This is not at all to give an overly rosy picture, and it's not to diminish the real systemic issues that many students on the spectrum and those with ID face. Schools like schools like the Justice Rottenberg Educational Center still exist, places that are using electroshock therapy to educate neurodiverse students, to say nothing of the pervasive and troubling use of restraints and seclusion against children with ASD. But nevertheless, the fact that we're talking about transition justice and the fact that we think we're comfortable talking about growing progress is, we believe, a sign of that progress is happening, even if the road ahead is still unclear and needs to be traveled. Let me lay out some of the issues relating to institutions of higher education, and then we'll transition to Hezzy to talk about the two other areas. So the IDA assumes that students with various disabilities have educational rights that end with secondary school. Nevertheless, we're seeing some progress as far as the development and extent of secondary education programs that are including, and the word is used cautiously, children and young adults with various disability issues. To put it into graphic perspective, a century ago, there were roughly 300 US higher educational institutions that offered practical coursework on eugenics, meaning that they were complicit in grisly experiments that were conducted on persons with ID and ASD living in other kinds of institutions. Imagine that, actually conducting the experiments. By contrast, right now we have about 270, roughly the same number, post-secondary programs for students on the spectrum and with ID that exist nationwide. So that's been a positive. The slow conversion of higher education institutions from facilitating human rights abuses against persons with disabilities towards promoting alternative sites for their inclusion was catalyzed by disability rights advocates, very often in conjunction with their parents and support groups, in the second half of the 20th century. Concurrent with parental advocacy efforts on behalf of their children with ID, accessing primary school education, the People First movement of self-advocates with ID precipitated the emptying of large congregate care institutions in the 1980s. And it's important to remember that our friends and colleagues who survived Willowbrook and other institutions are still alive even as they age and have very important lessons to teach us. You can access some of those videos not only on our website, but also on that of the self-advocates of New York State, SANI's, and other organizations. And yet, discrimination against students with disabilities continues to exist even within these programs, even as they continue to balance, as they say, competing interests. Discrimination occurs at least in three forms. One is the use of suspect admission criteria. NIMBYism continues to exist. Many of these programs still describe their admissions as being restricted to students with mild or moderate ID, and they use those terms as well as high-functioning individuals. There is some irony involved because programs, for example, like UNC's Greensboro's Beyond Academics, continue to bar students who have legal guardians, despite the prevalence of guardianship and despite many of these programs expecting parental support. There are behavioral expectations that many four-year on-campus programs expressly require from aspiring students with ASD and ID in order to conform to vague behavioral standards that frankly stink of ableism and are applied uniquely to the students with disabilities. So the University of Arkansas Empower program admits only students who don't demonstrate significant behavioral or emotional problems. Ohio State University's transition options requires every student to demonstrate the ability to maintain appropriate behavior in a variety of settings. And Clemson's Life program requires that students not be defiant towards authority. Ladies and gentlemen, we're talking about 18-year-olds. 18-year-olds without disabilities, can they actually abide by these standards? Maybe the people writing these standards haven't looked very closely at their cohort of normal mainstream students. The other way in which they use screening criteria is many of these programs demand family support. In other words, they are externalizing the cost of accommodations from their own ADA, Rehab Act, and IDA obligations onto the families themselves. And so UCLA's Pathways program requires every student have family support. Clemson's Life program requires that every student have parents, note the plural, who will support his or her independence. And the University of Colorado demands a commitment from the applicant's family or caregivers to support the goals of the students. The second way in which criteria are being applied unevenly to these students is that they often relegate them to second-class status within these institutions of higher education that are supposed to be inclusive. In other words, stay within your lane. Of 44 of these inclusive programs, only two, offer a path for these students to an undergraduate degree. In other words, you're welcome to be here. You're welcome to participate with certain qualifications, but don't even think of leaving here with a degree. Something's wrong with that picture. It should be obvious what is. Lastly, the implementation of these segregated and often biased disciplinary procedures are applied to these disadvantaged students in comparison to those students without disabilities. The College of New Jersey is unique in publishing its standards for students online. That's good. On the other hand, it expressly reserves the right to summarily dismiss a student if he or she fails to display appropriate dispositions within the program. What on earth is an appropriate disposition? Could students without disabilities be bounced out for not displaying an appropriate disposition? Let me give you a quick case study of a student with an intellectual disability who was part of one of these programs, and how she faced barriers to accessing healthcare services, how she was disciplined and questioned as to her behavior on a level which no other student without a disability would have been, because I think it brings into really graphic detail about it. So let's talk about Rosa, who is in the second year of an inclusive post-secondary program at a place not very far from Drexel. One day, Rosa, who has an intellectual disability, was observed by a program officer, an administrative individual, lying in the student lounge face down on a couch and moaning with her hands placed underneath her stomach. When the administrator approached Rosa, Rosa refused to respond to the official and didn't move her hands. The official immediately reported Rosa to the college for masturbating in a public space, not expressing concern about her condition, not asking if she needed assistance, but what's up, what's going on, and then reporting her for a disciplinary proceeding. This matter was relayed to Rosa's parents, who had to come down to the campus and were never allowed to discuss the incident with Rosa beforehand. Unaware of the report, Rosa explained very matter-of-factly that she had been experiencing painful menstrual cramps that day, was lying down and holding her pelvic area, and didn't respond to the official because it would have been inappropriate to discuss her private matters, her health matters, with a stranger in a public setting. Unexpected, inappropriate. When Rosa's parents asked that the official's report be expunged from Rosa's records and that a written record of Rosa's explanation be included alongside the official's report, these requests were summarily denied. The administrators insisted it would be better just not to make a fuss and to move on. Hezzy, let's turn to you for the last two sections on transfer of rights processes and other matters.
Sure, and thank you for giving me this opportunity. I'd also like to thank the organizers and all those who are present for today's really important topic. So I'll touch a little bit on some of the two other issues that might reflect how the IDA is experiencing growing pains with respect to students with ASD and other intellectual or developmental disabilities in these kind of transitional moments. And the first of these, the two remaining ones that I'll touch on, are transfer of rights discussions. So in 1997, the Individuals with Disabilities Education Amendments Act amended the IDA and expressly allowed states for the first time to transfer parental rights held under the IDA from parents to students. The vast majority of states, 90% since then, have adopted laws, regulations, or policies that do so with varying degrees of clarity. The IDEA, the statute, and its regulations basically lay out four main things. One, states can choose whether or not to transfer IDA rights from parents to students when the students become adults, according to the age of majority in that respective state. The transfer of rights does not apply to students, adult students who've been appointed, for whom guardianship has been appointed. Regardless of whether transfer occurs, parents retain a right to notice post-transfer. So not all rights under the IDA transfer to students if transfer occurs. And fourth, and importantly, states must create so-called special procedures to appoint representatives if an adult student who might be neurodiverse or might have intellectual or developmental disability and who's not subject to a legal capacity restriction imposed by a court are deemed by the IEP team to be unable to give informed consent, which the IDA requires for approving IEPs, conducting evaluations and revaluations, and also changes of placement. These 4 points seem pretty simple, but there's actually in practice a lot of confusion about what the federal transfer of rights provisions mean. Specifically, commentators, hearing officers, courts have wrongly interpreted the federal law to actually require the parental right, that parental rights transfer, when in fact it's states that are empowered to decide. So, you know, one example of a court that has got it wrong was in 2006, Bruno v. Greenwich Board of Education. The District Court of Connecticut, you know, made this mistake and said it's the federal law and not the state law that requires that parental rights transfer. And the court, and I'll touch on this a little bit again later, the court used that transfer of rights to basically to rule that the parent plaintiffs did not have standing to pursue FAPE violation claims, so violations of the IDA that the school had failed to provide a free and appropriate education for their child on that basis that they no longer were the rights holders. So maybe, you know, it's a little bit expected that, you know, a court might get things wrong. And there's a number of other courts that have done so in hearing officer decisions, but you'd think agencies like the National Council on Disability would get it right. But in its 2019 report, and I don't mean to pick on them, but I think it's just illustrative of the extent to which there's confusion about what transfer of rights provisions actually entail. In the National Council on Disability's 2019 report entitled Turning Rights into Reality, How Guardianship and Alternatives Impact the Autonomy of People with Intellectual and Developmental Disabilities, the National Council stated that the IDA requires, once students in special education reach the age of majority, the school to transfer all of their parental rights to the adult students as part of the transition planning process. And this is a clear misstatement of decades-old federal law. The IDEA and its regulations, again, do not require states to do anything. In fact, several states, including New York, Pennsylvania, Nebraska, and others, choose not to transfer parental rights to students at the age of majority. Although most have done so, you know, it's still a state choice, and unless there's a state law, regulation, or policy expressly opting into this transfer of rights provision, it shouldn't happen. But this confusion leads to guardianship, which is a serious incursion on important civil and human rights that persons with ASD and intellectual and developmental disabilities have. In recent years, you know, there's a growing body of evidence and there's a growing sentiment that there's something along the lines of a school to guardianship pipeline, that these transfer of rights provisions are inducing parents, and the conversations that special educators have around the transfer of rights are inducing parents to seek guardianship in order to preserve their right to assert IDA claims in court or in due process proceedings after their child becomes an adult. And it's really unfortunate that that's the case, even if it's a good thing for students to all of a sudden have the full rights that their parents previously had. to make decisions with regard to their IEP, it seems a little bit bizarre that that parents who've been, perhaps in many cases, their adult children's strongest advocates throughout their youth are no longer able to bring claims of IDA violations just because the student has turned 18 or 19 or in some cases 21. Just one example of this, a Fifth Circuit Court of Appeals case, Rays versus Manor Independent School District from 2017, kind of bears this out. In that case, the student in question turned 18 in 2010, and his mother filed a due process complaint in February 2013, so several years after the parental rights had transferred to the student in the state of Texas. And but the district the school district challenged her standing to sue on her son's behalf. And by April 2013, the parent had gone to court and gotten guardianship. Now, it's not clear from the court's decision exactly what the parent's motivation was, but the timing of it strongly suggests that, you know, one of the primary factors in the parent seeking this lifelong appointment of guardian was in order simply to bring an IDEA claim. And there's a lot of missed opportunities too. I would be remiss to fail to mention a minority of states, about a third of states, that have codified alternatives to guardianship in their state and statutes and regulations regarding the transfer of rights. But many of them, even though that's the law in the state, fail to notify parents and students of those alternatives that are available in their state law, not with in their guidance. So just one example of that, and there are multiple, is in New Mexico, which expressly in their transfer of rights regulations says that in addition to obtaining guardianship, students may execute a power of attorney for education decisions, and that would transfer rights from the adult student back to parents. And that would preserve basically parents' ability to pursue FAPE violation claims in court and also in due process proceedings. But their guidance and the procedural safeguards notice to parents just omits what that alternative to guardianship that is codified in that state's own laws. And so there's a lot of missed opportunities in this regard. And there's also, just to be perfectly frank, a bit of formalism in court decisions and hearing officer decisions that bounce parent plaintiffs or complainants out of the proceedings due to lack of standing because rights have transferred. In a handful of promising cases, but too few, courts and hearing officers have allowed parent plaintiffs and complainants to amend their complaint to substitute their adult child's name if rights have transferred on the complaint, so they can get to the merits of the case and the substance of the FAPE issues that they're raising. Without taking notice, or I'm taking notice at the time, and I want to get to the question of dual enrollment as well. But just some conclusions or some reflections. There's no reason why state education agency guidance shouldn't align with state regs and laws. And there's really no reason why these procedural safeguard notice shouldn't expressly let parents know about alternatives, whether they're codified in statute or regulation or not. And courts and hearing officers really should be, a bit more flexible in allowing parents, if rights have transferred, to substitute their children in amended complaints or amended filings. And there's, that's actually probably a reasonable modification that the ADA or Section 504, the Rehab Act, would require, even though I haven't seen a case where that claim has been made, although it'd be an interesting one. So quickly, I'd like to touch on this third issue of where kind of we see the IDA going through growing pains with respect to students with ASD and intellectual and developmental disabilities at this at the moment of transitioning from secondary to post-secondary education. And this regards to access to dual enrollment courses. So dual enrollment programs for secondary students to earn college credits have, in recent years emerged as an important mechanism to improve access to higher education. They're popular among students, and the National Student Clearinghouse last year reported that the number of students in dual enrollment courses has grown at an unprecedented rate. At the same time, states and policymakers like it too. It improves the strength of the workforce, and there's a substantial body of research that shows that, all other things being equal, students who dually enroll are more likely than their non-dually enrolled peers to finish high school, matriculate in a post-secondary education, and get a degree that's essential for accessing opportunities. And in fact, last year, 23 states passed new laws designed to expand access to dual enrollment opportunities for students. So this is a new emerging option that's available to many students, but it's really hard for students who are getting, and probably unnecessarily hard for students who have IEPs and are receiving special education services to access these courses and these opportunities on an equal basis with others. And one would think that dual enrollment programs would be a great way, another pipeline or pathway to give students with ASD, neurodiverse students with intellectual developmental disabilities, greater opportunities for post-secondary success. So the good news is that the Department of Education has issued guidance and resolved, its Office of Civil Rights has resolved a couple of complaints that establish that at least Section 504 plans under the Rehabilitation Act, it's the obligation of these of dual enrollment programs to ensure that those plans are implemented in the context of those dual enrollment courses, regardless of whether they high school students are actually attending dual enrollment courses on the campus of a post-secondary institution. But the Department of Education, fortunately, has punted on the issue of IEP, of whether IEPs should be implemented or must be implemented within the context of these dual enrollment courses. And it's strange because dual enrollment courses target secondary students who are covered by the IDA. In most cases, dually enrolled students who are receiving IEP or receiving special education services get both high school credit. So they're completing high school coursework at the same time that they're getting college credit for these courses. But nevertheless, there are, this is an issue where perhaps, some NIMBYistic attitudes among these kind of post-secondary education institutions are making these policymakers and educators, reluctant to embrace the IDA's mandates. And this kind of really comes out in a case that I'd like to share briefly, involving a kind of quote unquote twice exceptional student. I'll call him John. This is kind of also an interesting case where the IDEA, probably wasn't built to as a human rights statute. It was built as a civil rights statute, and it's not geared to give students opportunities to maximize their potential and to really flourish. But instead, there's kind of these baked-in presumptions that students with disabilities will perform worse in educational settings. And the case of this gentleman, John, this young adult John, this kind of twice exceptional student who is receiving intensive special education services through an IEP, but also is excelling in certain accelerated courses, kind of throws a wrench in some of those presumptions. So this gentleman, has been diagnosed with a series of conditions, right, that probably the original framers of the IDEA, really didn't have in mind for college-bound students. Things like microcephaly, autism, written expression disorder, auditory processing, and and then who names it? There's a series of other diagnoses that are documented in his IEP. But all of his IEPs have noted that even though he might have some limitations in some areas, as we all do, his transition plan explicitly includes post-secondary education as a goal for him. And for 1 year of high school, he participated in a dual enrollment program at a state university that had an MOU with his school district, whereby the school district agreed to provide or to ensure FAPE for him and to provide special education services in the context of that dual enrollment program. And it went great. So next year he wanted to try again. Applied to an accelerated gifted program, dual enrollment program for 11th and 12th grade students at another state university that matched his interest and was pursuant to his plan. And now his parents are in a Kafkaesque legal battle where, on the one hand, he's received high school transcript and high school credit for this dual enrollment. The state's legislation expressly authorizes the program to award high school credits to other students. But the program says it's based on the university campus, and they've asserted in their court filings that even though he has received, and I've seen the transcript, his high school transcript, getting credit for these courses, they've averred in court filings that they do not do this. And it's just immensely frustrating because he and his parents, like many in similar circumstances, are kind of forced into this strange choice between accessing these accelerated and expanding opportunities for students to get post-secondary education, while also, as kind of like a quid pro quo, being forced or pressured to waive their right to FAPE under the IDEA and waive their right to continue to receive the special education services. And so in this way, if the special education services that they're receiving under their IEP, set them up for success and position them, to excel and to take the next step, the IDEA in the current and DOE's interpretation of it seem to say, well, you're doing too good then, we're going to cut you off. And in order to access post-secondary education opportunities, which have been proven to reduce disparities and to promote equality for other students without disabilities who aren't receiving special education services, for you guys, we're gonna make it harder for you to get in, which seems like a strange and perverse double standard. Now, there are some good practices out there. It's not all doom and gloom. For example, Minnesota recently passed the Post-Secondary Educational Opportunities Act that expressly, in very clear terms, says for all dual enrollment programs, you have to figure out with the local education authority, often the school district, who's going to provide special education services in the context of dual enrollment programs. But whoever it is, whether it's the dual enrollment program that might be university-based, or whether it's the forwarding secondary schools district, someone's got to do it, non-negotiable. And that clarity is really, really important, because right now, if you're a student with ASD, ID, or developmental disability, and you're thinking about making the jump and to post-secondary education, and you want to do a dual enrollment program, right? Currently, if you go to any of these programs' websites, you're going to get very different guidance and very different interpretations about whether and to what extent you're getting the same services that have helped you succeed at the secondary level through your IEP at in this post-secondary program. So, it's again this kind of story of mixed messages. On the one hand, kind of low expectations, but on the other, students with diverse kinds of disabilities are, as we should come to expect, exceeding these low expectations and challenging policymakers and lawmakers and educational institutions to keep up, and for also the law to keep up. And so we should all try to, not only keep up, but keep a step ahead And that's why gatherings like this today are really, really important. So, I hope this, these brief remarks on how, we might question the extent to which the IDEA is delivering transition justice to neurodiverse students, students with ASD, IED, and developmental disabilities, or other cognitive disabilities, is actually fulfilling that promise, and whether we need to employ certain strategies to ensure that everyone gets a fair shake and everyone has the opportunity to flourish and maximize their potential. So thank you. And I don't know if we'll have time for questions. Oh, it looks like there might be, but I'm happy to receive them. I know we're at 11 o'clock.
Thank you both so much for such an enlightening and thorough discussion, and for the work that you are both doing to address these issues. We do have some time for questions, and we have some questions that have already been submitted to the Q&A, but we will start with this one question. Is there any data on how many school districts are using supported decision-making instead of pushing guardianship as part of the transfer of rights process?
Sure, that's a great question, and we're actually working on that. And there's kind of a question as to what's on paper and what happens in practice. And so there are at least, District of Columbia has a formal policy whereby students might use supported decision-making to both kind of get the best of both worlds, keep their parents in the picture, but also have the opportunities to make decisions. It's unclear, honestly. I haven't seen anyone with a supported decision-making agreement where their parents try to bring a FAPE claim in court, right? And because supported decision-making agreements don't transfer rights, presumably rights are still in the student's hands, and so the parents might also face a barrier there. So that might actually not solve the problem, the specific problem of being able to sue once a child is an adult, or student becomes an adult. But there are some interesting, like very specific. So not lots, but maybe about 11 states have formal delegations of rights where students sign a form. It's less than a power of attorney, but gets the job done. Just says, I want my parents to be able to sue and to be able to make decisions with regard to my IEP on my behalf while I'm an adult. So those are voluntary things, and we're compiling that. And hopefully later this year, I'll be publishing a 50 state, well, plus DC and Puerto Rico database that makes that information more available. Oh, and then Massachusetts is doing something, I think, which is we should all, kind of look to. It's shared decision-making. So there's no reason why, it has to be an all or nothing either or. Either the parents have the rights or the students have the rights. While the shared decision-making, at least in Massachusetts, due process proceedings, I don't think completely solves the questions about who can sue. I think it is a promising kind of way to, get the best of both worlds.
Great, thank you for that. We also have a question that someone will ask live. Darlene.
Yes, hi. Thank you for your presentation. I'm an attorney in Pennsylvania, and one of the issues that I've been looking at is around transition services and transition planning under the IDEA, and how, although it's fairly well laid out in the law, in practice, it's not very, or for a lot of students, it's not actually very effective. And I was just wondering if you could talk a little bit more about what you see as the relationship between the issues that you talked about and transition planning that's required under the IDEA. Like, is there ways that we can use the transition plans to ensure that students who would benefit from dual enrollment programs, have that in their IEP, or things of that nature?
Yeah, and it definitely strengthens the student and the parent's hand to have baked into the IEP specific kind of post-secondary and dual enrollment goals. Not all VR agencies or school districts are up on how IDEA Part B funds can be used to support enrollment in those programs, unfortunately. And the guidance is kind of, the DOE has put out some guidance. It's not kind of a recipe yet. It's not like a how-to manual. It's kind of just permissive and says, you can do this, not how does one do this. And so it's still, I think, a little bit the Wild West, but getting those goals stated in the IEP, and the gentleman that I mentioned, John, part of the reason why they got access to the first dual enrollment program and had a good experience there was because they advocated for inclusion of post-secondary goals and dual enrollment specifically in his IEP. And the AG in that state agreed with them in a decision that he had issued at the time. But nevertheless, it's not a silver bullet. So I'm happy to talk offline more about some of the specific issues because that's also a very broad question. So,
and we should also add in that these are very influenced by expectations.
yes.
Right. So if we're looking just at what the law is, a lot of school districts interpret that as saying, okay, well, as part of your transition plan, maybe there's the possibility of going on to post-secondary education. And there are courts that have found that to be an adequate level of detail on a transition plan. But if you don't expect these students to go on with their educations, if that's not part of your expectation, and if the decision-making is, kept from the students themselves and or their parents, the expectations can be dictated by these kind of flimsy IEP expectations.
Thank you. We have another question in the Q&A. Although rights transfer can often enhance students with intellectual disabilities, self-determination, and autonomy, is there anything that can be done to mitigate the drawbacks of right transfers with respect to enforcing their IDEA rights? You had mentioned alternatives to guardianship, such as power of attorney. Are there other avenues available?
Yeah, and I think that's a great question. I don't want to presume that the paper transfer of rights actually enhances ipso facto, self-determination and autonomy. It definitely creates interesting opportunities for it, but it's not treated and practiced often as like a learning opportunity, where this is what the transfer of rights means. Often it's just a box that IEP teams check off when the student turns 17 in most cases, but 1 year before the transfer and then at the moment of transfer. And even though, for example, I just would like to ding the federally funded PTI centers because the IDA statute expressly requires parent training information centers to provide information about transfer of rights, responsibility, and responsibilities to both parents and students. But I've seen a paucity of guidance for students about what the transfer of rights means. And this could be a huge learning opportunity, the same way that promising practices such as student-led IEP meetings can enhance self-determination and autonomy. I think it's really, really important that one, the DOE look into the extent to which PTI centers are fulfilling that obligation that their funding is contingent on, but also with regard to specific alternatives to guardianship, things like power of attorney. Often you can do it even if the state doesn't have a specific regulation recognizing it, although that does help. But just simple forms, even included on the IEP, where there's a box and it says, the student, I would like, my parent to do this, is really important. So a couple of states like Virginia, and there's a handful of others that we'll be putting in our database that will be public by the end of the year, have where it's literally just a form to say that the Department of State Department of Education recognizes and develops that says that I want my parents to retain educational decision-making rights. In an ideal world, there's a robust kind of shared decision-making practice where students and parents can both sue. There's no reason in my mind why even if rights were to transfer to students, and even if parents wanted for that, the IDA and also state laws, couldn't allow parents to also bring suit. And that could just be an issue of, being allowed to substitute adult students as plaintiffs or complainants to kind of check that formalistic box.
Thank you. So we have 5 minutes left, but we do have one final question that we will take. And Regina, you have the floor.
Hi. So I typed it into the question and answer, but I'm just wondering if there is case law to support parents maintaining the educational rights of their young adult children, especially if the district failed to notify the students and parents of that transfer of rights the year prior to them turning 18. So there was no ability to prepare for the transfer or talk to parents about maintaining rights through a waiver rather than pursuing guardianship. Just wondering how OAL or the higher courts dealt with parents not receiving the legal notification and the student receiving the notification.
There's a couple, and I'm happy to share the specific sites with you over email. I think I have it, and it's a great question, but the key issue here is that often, and this kind of applies broadly to IDA violations, procedural violations, often just a procedural violation isn't enough to prove that the right to FAPE has been violated. So there has to be some barrier to the substantive participation of the parents or in the adult student's educational programming. So if, for example, the failure to notify prevented them from participating in IEP meetings thereafter, that would be an example. But there has to be kind of, a showing that it's not just a procedural violation, but there was actual harm. And so courts, there's been a couple of courts that I've seen, they've recognized, yeah, there was a failure to notify, but it didn't actually prevent the parents from participating in decision making, and so it doesn't result in a FAPE violation. So, I'm happy. There's a couple of sites that are a little, I think, a little helpful on this question. So I'm happy to send those. And interestingly, and just I would just like to add that there's at least one state's regulations that I've come across where there's an obligation on the special on the IEP team or the school district to not just notify, but to discuss and inform. And I think that if we're thinking about practice, requiring affirmatively school districts to educate, not just to notify, would be to the greatest benefit of everybody. And so that's something that can change just in a state education's practice manual. It could also be something that a local school district resolves to do at a practice level. But instead of just notifying, actually educating both students and parents about what this means.
Again, thank you both so much. I know we are kind of speaking into the void right now, but I hope that everyone joins me in thanking Professor Stein and Hezzy for their wonderful discussion, and thank you for fielding our questions as well. And again, thank you both so much for your time today. We really appreciate it.
We can't see everyone's beautiful faces before we go.
Happy flappies.
Yes.